Because if someone goes in your backyard, you could blow their heads off.
A Florida woman allegedly took matters into her own hands, literally, by pulling a gun on two teens and threatening to kill them for fishing behind her backyard. But in a twist she did not see coming, instead of the teens getting in trouble, she's the one that got arrested, and it was all caught on camera. Adding to the irony, it wasn't the boys who called the cops, it was the woman herself. I'll break down what happened and walk you through the details. For Law and Crime News, I'm Kennedi Walker. Two teenagers, just looking for a quiet afternoon of fishing, instead found themselves staring down the barrel of a gun. According to court documents, the 15 and 13-year-old boys say they were simply trying to fish in a pond behind 59-year-old Donna Elkins' home when she confronted them, allegedly screaming, threatening, and ultimately forcing them to the ground at gunpoint. And part of the terrifying ordeal was caught on camera. In one chilling clip posted to Facebook by one of the teens' uncles, Elkins can be heard berating the teens.
You don't walk into someone's backyard private property.
One of the boys can be heard responding respectfully.
Yes, ma'am. Trespass.
But Elkins does not back down.
Police pushes on is mine. Do you get people in your backyard?
Sometimes, ma'am.
When one of the boys admits that sometimes people do wander into his backyard, Elkins is heard responding.
That's definitely sad. Because if someone goes in your backyard, you could blow their heads off. I have a right to protect my property and my house.
The teens, terrified, were reportedly ordered to lie in the grass and not move. Another clip shows a man, later identified as Elkins' husband, finally stepping in and removing the gun from her hands. At some point, Elkins herself called 911. According to an affidavit, Elkins told dispatchers that she had petrified them and that she had stopped them and they were laying on the ground. She later said she had walked into her backyard with a pellet gun, intending only to scare the boys. And, well, mission accomplished. When deputies arrived, the teens told them they feared for their lives. They claimed they had simply been trying to fish when Elkins emerged, pointing a weapon at them and threatened to, quote, blow their heads off. Elkins then allegedly ordered them not to move and prevented them from leaving. For around 5 minutes, the boys remained frozen in fear until her husband finally took the gun away. But here's the kicker. Police determined that the pond the teens were trying to fish in was actually 30 feet away from Elkins' property line, according to court documents. Two juvenile witnesses reportedly confirmed to investigators that Elkins was armed and had shouted at the boys while they laid on the ground. According to the sheriff's office records, Elkins was arrested and booked into the county jail. Now, what started as a simple fishing trip has turned into a legal battle that could cost her her freedom. Elkins faces 2 counts of both aggravated assault and false imprisonment, which is a third-degree felony in Florida. She was released on a $25,000 bond. And joining me to talk more about this is legal expert Kathleen Bogenschutz. Kathleen, thank you so much for coming on today. We can just jump right in. At what point does protecting property cross the line into criminal behavior?
Well, I mean, when obviously in this case, but I don't really even think that I have very much legal advice for people. I just don't understand how to explain to people that maybe you should care about each other and care about each other's kids. And if these kids, it's clear from what's written in these reports that she reported to 911 that they were just fishing. It's not like she mistook the fishing rods for AR-15s or anything like that. So they were fishing in my pond and I went out and held them at gunpoint. I mean, the drastic escalation there is something that I think a jury is not going to take kindly to, especially considering the age of these kids too.
And hypothetically, because a defense attorney has to find some way to argue their case. Could a defense attorney argue Florida's stand your ground law in this situation?
So stand your ground is more of a outside of your home type of a thing. It does apply. I mean, you don't leave it at the door, but she's probably going to say that they were trespassing on my property and I had every right to order them off. But it seems like from what I'm reading here that she basically made them get on the ground and wait for the cops to get there And as opposed to just saying, hey, you're trespassing, get off my property. And it also looks like it's 9 p.m. So yeah, it's dark out, but I mean, they're fishing. Is this really something that we're willing as a society to say that you get to come out and hold minors at gunpoint because they're fishing
Right.
on your property? I mean, I think back to when I was a kid in the 80s and 90s, and how many properties I probably trespassed on, and these kids are probably just absolutely petrified. Yeah.
And that's definitely what they told police. Those kids said that they feared for their lives. And the kicker here is, according to police, the teens were actually 30 feet away from her property and not technically on it, allegedly. If the teens had actually trespassed, would she have had any legal right to detain them?
Yes, but I just don't know if it could just be the former prosecutor in me, that I just don't feel personally that it's reasonable to hold a young teenager at gunpoint if they're walking, even if they were walking through your property. If you have no basis to believe that they're armed and they're clearly there with fishing rods, it does not it seems highly unreasonable to me. And I could tell you that the stand your ground law was passed while I was still a prosecutor. And I remember all of us getting together the day after it passed and going, our lives are about to get so much worse because it almost like it does. It immunizes someone from basically escalating something. And you saw that in the George Zimmerman case where he was told not to follow Trayvon Martin, and he did. And then when he got punched, he got to shoot him and was acquitted by a jury. And I think the jury made the right decision in that case because of what the law was. I just disagree with the law. So
And
I mean, they
for
weren't even on
those
her
that may not
property.
understand, do you mind just explaining what the stand your ground law is?
Yeah, so there used to be a common law duty to retreat in Florida. That basically, if something's going down, if you can retreat from an altercation, and safely, that you should do that. That should be your first move as a person in society. Stand your ground means that you do not need to retreat, and in fact, you can stand your ground, meet force with force, and essentially, it codifies escalating things further. So when we're talking about the Trayvon Martin case, we're talking about somebody who was George Zimmerman was told on the phone, "Don't follow this kid. You're not a cop. You know, you're not imbued with any police powers." And he decided he was going to continue following this kid and continue following this kid. And there was an altercation, and he ended up shooting and killing him. So the duty to retreat there, like, maybe not to engage because you're not a police officer, you're not supposed to be there. We're not playing Team America World Police. And I realize I'm dating myself by saying that. Um, but that you have some sort of a duty to let other people live without encroaching on them. And in this case, the fact that they weren't even on her property, I, I don't know. I feel like our first move on the defense end would be a psych eval for her, just to see why we're running out somewhere that's 30 feet from our property and holding kids at gunpoint, wondering if you're ever going to see your parents again. It's a long time.
And you just touched on something that I wanted to expound more on. So the defense team, they may want a psych eval for their client. What exactly does that entail? And let's say they do find something that says, okay, yes, she does have a mental issue. Would that allow her to get off?
No, I mean, it would be more mitigation. Mitigation meaning that we're going to take that into consideration with sentencing and maybe what we do with her, even to see if she's competent to stand trial, because she needs to know, she needs to be able to tell right from wrong. And the fact that she did this off of her property and then called 911 as though she was almost, she was reporting it to police and was expecting them to arrive on her side. That to me, I don't know. And it's possible we're not getting all the facts here, but to me, like that, something there doesn't jive to me. If she's, instigating this and then calling 911 and saying, I've got these kids at gunpoint and they're face down on the ground. It's it just doesn't make sense to me. And it also is possible that even if there's something that makes the state drop the case, that if there's some kind of mental health issue, that maybe we take some steps to take that gun away from her in the future and to make sure she's not able to own guns in the future. We've got red flag laws now in Florida, and depending on what's in a psych eval, that might be something to look into.
And supposedly the gun that she had was actually a pellet gun. Can pointing a pellet gun at someone still be considered aggravated assault?
Yes. So I had an aggravated assault with a lamp once. It aggravated assault is threatening somebody with a weapon that could be a deadly weapon. So I could use a lamp. I could use a bat. For some reason, there's a considerable number of machetes in South Florida. We had a ton of machete cases where I guess because they were on hand, that's what was available. And as far as aggravated assault with a firearm, the firearm statute in Florida says that so long as it's capable of expelling a projectile and is functional, I believe a pellet gun would probably fall under that statute. I don't know enough about the gun. I haven't seen it, haven't tested it myself, but it sounds like that might fall under the statute for a firearm.
And can you explain, how does Florida law define false imprisonment? And does ordering someone to the ground at gunpoint qualify, even if it is that pellet gun?
Yeah, I mean, if false imprisonment, I don't have the statute pulled up in front of me, but it's curtailing somebody's ability to leave without any lawful right to do so. So, I mean, obviously, if you're a police officer and you're detaining somebody who was shoplifting, you have at least the right to do that. If you're loss prevention at Walmart, you have the right to do that. There's a shopkeeper's privilege that you would be able to detain someone. False imprisonment is, I mean, it sounds like this meets the criteria for that. And in fact, it might meet the criteria for armed false imprisonment.
Would Elkins's claim that she only intended to scare the teenagers have any legal merit in court, or the fact that, again, it was not a real gun?
Her intent to scare them is the issue with the aggravated assault statute. Aggravated assault, it is actually the statute itself reads aggravated assault without intent to kill. So it doesn't matter that she only meant to scare them. If she only meant to scare them, she's kind of helping the state prove up an element.
And I was just about to ask, how do prosecutors typically prove intent in cases like these? But with the 911 call and her allegedly admitting this over the phone, is this like a open and shut case?
Well, taking the reports and the news articles at face value, assuming there's not something else out there that we don't know about, it seems like it fits in the box with 90-degree angles as far as an aggravated assault case. And particularly when you consider the fact that it appears that they weren't even on her property. So she just decided to tame America World Police, go bother these kids who were fishing at night. And I couldn't, again, it's not legal advice, but I can't stress enough that I feel like we as American citizens, you should care about people in your community enough to not want to scare them to death when they're fishing. You should care about your neighbor's kids enough to not want to scare them to death when they're out fishing. And maybe having a little bit of empathy and putting yourself in their shoes at their age is something to think about when we're, maybe approaching retirement and thinking these kids are playing their music too loud, essentially.
Could
I'm not
Elkins
saying
argue that
music in this case. It's
yes.
just
Yeah, no, I understand what you're saying. Could Elkins argue that she mistakenly believed the pond was her property? Would that affect her case?
She could try to argue that. I don't know when she bought the property. I don't know how long she's lived there, but I, I have a real difficult time believing that she was 30 feet off from where her property ended or began. Now, granted, it was at night, so maybe she just didn't appreciate that, but I mean, they weren't hurting her. Like, I like I said, I'm not a big fan of the stand your ground law personally. But even here, it doesn't even, I mean, she brought the fight to them. It's not, she's the instigator here.
If convicted, what kind of sentence could she possibly face?
So, if this pellet gun qualifies as a firearm under the statute, and they'll have somebody at the lab in the firearms section test it, compare it to the firearms statute, and somebody will make an argument as to whether or not it applies. Um, it doesn't matter. We took the minimum mandatory off of aggravated assault with a firearm, I think in about 2018, so long as the firearm wasn't discharged. So there's no min man on that. I assume she's going to be charged with 2 counts of aggravated assault, one for each of the kids. And each one of those is punishable by up to 5 years in Florida State Prison. I don't know what her criminal history is, and I don't know anything about uh, either one of these kids having any sort of back story with her on the property, anything like that. Doesn't appear that there is. But yeah, if you were to stack them, you would be able to get 10 years. There's an argument that because it was one act, you cannot stack those 2 counts, one act on 2 victims. So you would only be able to go up to 5 years in prison. That being said, the minimum would be 0 so long as she doesn't have priors.
Now, could the fact that her husband, took the gun away help her defense in any way, or is that a stretch?
I don't know. I mean, to me, it sounds like, as somebody who is also married, maybe she was able, or maybe he was able to identify that his spouse had kind of gone off the deep end a little bit and decided to intervene. I mean, it almost, to me, the way that I'm reading it, to me, it almost underscores the fact that he thinks she's acting unreasonably. Like, if I think my husband's holding somebody at gunpoint that's a danger to my house and my property and whatever, I'm just going to say, good, have at it. You stay there. If I walk up and take the gun away from him, that might be a sign that I think that he's not acting reasonably.
What are the chances of Elkins negotiating a plea deal to lesser charges?
It depends. It depends on what her priors are. Florida has a law called Marsy's Law. It's Marsy, kind of an unusual spelling. And it's basically a victim's rights law. So the victims of this offense, now granted they're teenagers, do have some input in how things are disposed of in this case. And I'm assuming their parents will have some input as well as to how this is disposed. Now, it doesn't mean that, if they want her buried under the jail, that they're going to get it. But that law indicates that the victim's rights are as important as the defendant's rights, that the victim is allowed to have some say, and that the judge should hear the victim out if the victim wishes to be heard at sentencing. So, I have to imagine that they will want to be heard after going through this.
If she is convicted, could she still be eligible for probation instead of jail time?
Yes. So we use score sheets in Florida. If she has no priors, the way that the score sheets work is it's a math equation. Each offense is assigned, and not to get too in the weeds, each offense is assigned a number. She's going to have 2 counts of aggravated assault, I assume. It might get merged into one. She will then score, I think, math is hard, something like 42 points. If you score 40 4 points, that is a presumptive state prison sentence. If you score under 22 points, there is a presumptive sentence that you are not going to prison. And 22 to 44, it's a discretionary thing with the court. So, and again, there's all kinds of exceptions that are available. So I'm just glossing over it here. With no priors, with these kinds of charges, even if she were to go to trial and lose, I don't really think she would be going to prison unless there were signs that this was a significant problem and maybe was a recurring issue here, with her doing this to people she suspected were trespassing on her property. And it's also possible that, maybe there's some kind of mitigation here where her house was broken into last year or something like that, where she's terribly, I don't know, sensitive to somebody lurking around her property. I just don't like it.
Right. And the suspect allegedly did tell police that the reason why she did this was because she did fear for her life and she was scared. Uh, if there had been no video, would this case be harder to prosecute?
Yeah. Yeah. I mean, videos are always, I, I used to tell juries when I was a prosecutor, videos don't lie, audio doesn't lie, people lie. And, even if people have every intent to tell the truth, when you're in a high stress, high stakes situation like this, the video is the better witness when you have that kind of an adrenaline rush through your body. So, I mean, videos are, if a picture is worth 1,000 words, a video is worth 1,000,000. We'll leave it at that.
Not just that, but also that 911 call. Could the fact that Elkins
Mhm.
herself called 911 hurt her case in court?
Well, I mean, I'm sure her lawyer will try to argue that, well, she thought she was in the right and called 911 and thought that she was bringing these, I don't know, I guess prospective fish burglars to justice. I just don't. I'm not really understanding. Like even the most expensive stocked pond, are you really going out there with a gun? Like,
Right.
you're stocked with the rarest form of rainbow trout ever possible. That's a delicacy. I mean, are you going out there with a gun for somebody
Could
fishing?
could could she potentially face civil lawsuits from the teens' families, even if she's not convicted?
Yes, you can sue, for all kinds of. So a tort would be a civil wrong in Florida. Here, I can identify a couple of them. I mean, it's she falsely imprisoned these kids. Obviously, they thought it was good enough to file criminal charges against her. But I mean, a civil case would allow you to go after things like, intentional infliction of emotional distress, which I think you probably have in spades here.
Could the husband be charged for not intervening sooner?
Um, I don't. There's no duty to intervene, with civilians. Um, I I I don't. I'm sure in a very rare case there might be something where you could look at that, where there's just an extreme example of somebody standing by while this is occurring, but I I doubt it. And again, the fact that he did intervene as somebody who, like, I consider, like, what would it take for me to go over to my spouse and take the gun away from him? It would be me thinking that, man, he is a little out of control right now.
Right.
So I
Well,
have
this
to
is a
imagine that that was his thought too.
yeah, for sure. And this is a case that we will for sure be following and watching. Thank you so much for coming on today. We really appreciate it.
Thanks for having me.
Her arraignment has been scheduled for Tuesday, April 22nd. For Law and Crime, I'm Kennedi Walker.